Alors, bonjour à tous. Good afternoon, everyone. Je m'appelle Patrick Leblond. Je suis un professor in the Graduate School of Public and International Affairs at the Faculty of Social Sciences. So this is a part of an inter-faculty collaboration. Je suis également titulaire de la chaire CN Paulin Tellier en entreprise et politique publique, et donc mon intérêt, bien sûr, du commerce international. I'd like to welcome you to today's panel discussion to debrief WTO, World Trade Organization's 13th Ministerial Conference, which took place in Abu Dhabi at the end of February. Aujourd'hui, nous avons l'honneur d'avoir des expertes et experts du commerce international pour vous expliquer ce qui s'est passé à Abu Dhabi. Nous avons, ceux qui sont à l'écran, vous n'allez pas voir, nous avons Geneviève Dufour, qui est professeure titulaire ici à la Faculté du droit. Nous avons Léonie de Rome, agente principale de la politique, qui est en ligne à Affaires mondiales Canada, aux négociations commerciales. Nadia Borelli, qui est ici en présentiel, qui est directrice exécutive au bureau du droit commercial à Affaires mondiales Canada. Katrina Ellis-Cannon, who is also in person here, who is Deputy Director, Services Trade Division at Global Affairs Canada. Nous avons Pierre Citeau, qui est présidente de Trade Bridges et professionnel en résidence à l'École supérieure d'affaires publiques internationales à l'Université d'Ottawa. And Matthew Smith, who is also in person, who is the Chief Agricultural Negotiator and Director General at Agriculture and Agri-Food Canada. Unfortunately, we were supposed to have Andrew McCracken, who is the Executive Director of Trade Remedies at Global Affairs Canada, but unfortunately, he has fallen ill and he cannot be with us today, so wish him well. Donc, la séance d'aujourd'hui va se dérouler comme suit. On va avoir une mise en contexte de la part de la professeure Dufour. Ensuite, on va avoir les présentations par nos distingués invités d'Affaires mondiales Canada et Agriculture et Agroalimentaire Canada. We will have a Q&A with the audience, so it will be your chance to ask your questions and get answers, and it will be moderated by Faculty of Law Professor Celine Brown. And after that, you're all cordially invited to a small reception. So after all this information, you can kind of digest it with some food and drinks. Avant de donner la parole à ma collègue Geneviève, deux premières choses. L'affirmation autochtone. Donc, j'aimerais qu'on rende hommage au peuple algonquin, qui est le gardien traditionnel de cette terre. Nous reconnaissons le lien sacré de longue date unissant ce territoire qui demeure non cédé. Nous rendons également hommage à toutes les personnes autochtones qui habitent Ottawa, qu'elles soient dans la région ou d'ailleurs au Canada. Nous reconnaissons les gardiennes et gardiens des savoirs traditionnels de l'âge. Nous honorons aussi leurs dirigeantes et dirigeants d'hier, d'aujourd'hui et de demain au courage indéniable. Donc, se rappeler que si on est ici, ça n'a pas commencé avec nous. Voilà. Et pour poursuivre, j'inviterai les doyennes, donc Dean Kristen Boone, who is the Susan and Perry Delelche, I'm not sure I'm pronouncing this right, Dean here at the Faculty of Law in the Common Law section. So, Dean.
Thanks very much, everyone. It's really a pleasure to have you all here today. Welcome. I'll just take a minute to say that we are so thrilled to have the opportunity to host this conversation. We really pride ourselves on being at the forefront of international law, being a forum for discourse. We are delighted that Professor Gabrielle Marceau has associated herself with us as a visiting professor, and thank her very much, along with Geneviève Dufour, for bringing this wonderful panel here today. I think, both the media and current academic discourse tend to highlight that there is a paralysis or a lack of willingness to engage in the international system. Thank you. Yeah. Both the media and current academic discourse tend to highlight that there's a paralysis in the World Trade Organization, World Trade Affairs. But I think the fact that we have Canadian officials so deeply engaged in the next stage of negotiations and how member states are still manifesting their commitment to WTO actually shows the converse, that there is a lot of dynamism and optimism with regards to the future. So, we're really lucky today to have this debrief about the WTO's 13th Ministerial Conference. So thank you very much for joining us. As members of the academic community, we're very glad to be here to welcome our distinguished panelists and look forward to the conversation today. Yes.
Thank you. La faculté de droit de l'Université d'Ottawa est une entité assez particulière. Il y a deux sections. Vous avez eu la version Common Law et maintenant il y a la version droit civil. Donc j'inviterai Marielle Sylvestre, la doyenne de la section de droit civil à l'Université d'Ottawa, de venir vous dire quelques mots. Merci.
Bonjour, bonjour à tous, good afternoon. Il me fait vraiment très plaisir de vous accueillir pour cette session particulière, un debrief on the 13th WTO Ministerial Conference. C'est vraiment un honneur et un plaisir d'accueillir cette délégation extraordinaire qui nous honore par leur présence. Je veux souligner le leadership de Gabriel Marceau, qui est professeur invité maintenant à la faculté de droit, ainsi que celui de Geneviève Dufour, qui a contribué à organiser cet événement. On était très fiers que Geneviève se joigne à nous l'année dernière. Elle est maintenant titulaire d'une chaire de recherche sur le commerce international responsable, durable et inclusif, et elle se joignait à la faculté de droit qui compte un nombre absolument impressionnant de collègues à la faculté de droit, mais aussi ailleurs, qui touchent au commerce international, aux investissements étrangers, dont certains d'entre eux sont dans la salle aujourd'hui. Donc, notre faculté, comme le disait le professeur Leblond, donc forte de ses professeurs en droit civil, en common law, à la rencontre de systèmes juridiques distincts, y compris les traditions juridiques autochtones en français et en anglais, de par sa situation géographique et stratégique, qui est vraiment placée de façon idéale pour discuter des enjeux de commerce international. Donc, c'est vraiment un plaisir de vous accueillir. Bonne discussion et merci beaucoup.
Alors, donc avant de passer, disons, partie où chaque panéliste de nos collègues du gouvernement du Canada vont parler de leur secteur en particulier, j'inviterai Geneviève Dufour, comme je l'ai mentionné, qui est ma collègue ici à la faculté de droit, à venir faire une mise en contexte de ce que c'est les conférences ministérielles et en particulier la conférence ministérielle à 13e, et donc un peu mettre la table, si on peut dire. So, Geneviève.
Thank you, Patrick. Bonjour tout le monde. Hi, everyone. I was in Abu Dhabi in last February as a delegate for Cameroon, which I'm assisting as a technical expert. So Gabriel asked me to make a few preliminary remarks, which I hope will provide food for thought for all of us and for the next discussion. Firstly, I think it's important to recall that the WTO is the only multilateral trade negotiating forum that sets the rule for free trade. What happens at the ministerial conferences, usually held once every 2 years, has a major impact on the course of international trade, but also on the flexibility states have to regulate their products and services on their territory. So I used to say that when ministers from 166 countries representing 98% of world trade meet for 3 to 5 days to make decision, we must take interest. Above all, we have to recall that the WTO is an organization with a different way of doing. Its first distinctive feature is that almost all decisions are taken by consensus. This means that if just one of the 166 countries object to a new rule, to a new interpretation, or even to putting a new subject on the agenda, nothing will get done. It should also be noted that the majority of the decisions are taken within the framework of the single undertaking. This means that we are not negotiating one or two decisions or one or two treaties during the ministerial conference, but a set of texts for which the agreement of all members must be obtained. So now that you are expert in the matter of the WTO, what happened in Abu Dhabi? En arrivant à la ministérielle, on avait un paquet de textes, le single undertaking, donc un paquet de textes qui couvrait 4 sujets majeurs à l'OMC et qui sont fortement négociés depuis des décennies. Agriculture, réforme de règlement des différends, accord 2 sur les subventions aux pêches et commerce électronique. Durant la conférence ministérielle, vraiment, rien n'était gagné. Plusieurs ont même évoqué la possibilité qu'on parte sans résultat, sans déclaration même, ce qui a été un échec total. On sait que l'Inde bloque le jeu des négociations depuis 2013. L'Inde a bien compris le concept du consensus. Aussitôt qu'elle s'oppose à une décision, il n'y a plus rien qui avance. Et cette année, l'Afrique du Sud a joué le jeu de l'Inde. On est néanmoins reparti de la ministérielle après 2 jours de prolongation avec une déclaration ministérielle, avec 5 décisions ministérielles thématiques et 2 déclarations ministérielles thématiques. C'est donc une victoire. Comme observatrice, je dois souligner le fait que cette conférence a été tenue d'une main de maître par la directrice générale, Ngozi Okonjo-Iweala. D'un point de vue de la méthode de négociation, on pourra peut-être y revenir avec nos experts. On peut mentionner qu'il y a eu de nouvelles façons de faire qui ont été mises de l'avant pour promouvoir notamment la transparence, l'inclusion dans la négociation. C'est pas encore parfait, mais il y a eu de l'amélioration. Parmi ces innovations, on a assisté à 2 discussions ministérielles qui sont venues brasser des sujets extrêmement sensibles en commerce international. Premier sujet, toutes les nouvelles politiques d'industrialisation basées sur le développement durable. Et deuxième conversation ministérielle, le commerce et l'inclusion. Donc, les femmes, les pays en développement, les micro, petites, moyennes entreprises. On ne peut pas dire que les membres de l'OMC n'ont pas abordé les questions qui fâchent. Enfin, on doit souligner une présidence de la conférence ministérielle assez discrète de la part du ministre d'État au commerce extérieur des Émirats arabes unis, mais un accueil ô combien chaleureux qui a probablement joué en faveur de l'obtention d'une déclaration finale. L'Inde a d'ailleurs déclaré donner son appui à la déclaration par amitié pour le président émirati de la ministérielle. So in the end, few visible advances in the official outcomes, the text adopted, but major advances. First, some unadopted texts have nevertheless moved forward. For example, the chairman of the Agriculture Committee spoke of a historic advance. We'll see. Second, advances in practice. China finally agreed not to benefit from its developing country status under the second agreement on fishery and invited a similar country to do the same. Third, I would say major advance in the way negotiations were conducted. Greater transparency, better inclusion for developing countries, new ministerial conversations. And fourth, advance in the speeches that were much more frank than usual. For example, Catherine Tai, the USTR, opened up about the reality of the United States, the rise of populism, the constraints her administration was experiencing. And during the first ministerial conversation on the first day, she asked members, what can you do to ensure that a country like the USA continues to benefit from its membership of the WTO? And in fact, she had just asked the ministers not to read their speech and to speak, to have a real discussion, a frank conversation about their own reality. So in conclusion, I would say that I am an internal optimist. So I see in all this the augury of a productive next ministerial. The next ministerial conference will be held in 2026 in Cameroon, my delegation. So we are in the preparatory phase. Many elements, of course, could contribute to a happy ending, but many others could cancel out these advances. Clearly, I think we must remain vigilant if Donald Trump returns to power. It will be a challenge for WTO. And obviously, we need to find a solution to bring India back into the multilateral game. India doesn't play a team game. Especially, I hope we'll be able to do the same thing in 2026 with our 5 experts, and that my optimism won't be dismissed as a kind of idealism. Thank you.
Merci Geneviève. Cette note optimiste, en espérant que ça continue. Donc maintenant, j'aimerais inviter Léonie de Rome, the Senior Trade Policy Officer and Trade Negotiations at Home Affairs Canada. I don't know if Léonie is there. Probably might have to.
You'll just be able to unmute them.
Yeah, okay. It's just it'd be nice if we could see her.
I think she will pause. Yeah.
You think?
Pause. Oh, there she is.
Okay, all right. Léonie, la parole est à vous.
Merci beaucoup, professeur Leblond. J'espère que vous pouvez tous m'entendre et me voir. Merci beaucoup à la professeure Dufault pour son introduction également. So good afternoon, everyone, and thank you to the organizers for inviting me to this panel today. I'm very happy to be here, provide my views on MC13 and also discuss Canada's positions and share some perspectives from the ground in Abu Dhabi, where I was also. Aussi, en tant qu'ancienne étudiante en droit moi-même, je suis particulièrement contente d'être ici. Puis ça me permet aussi de vous démontrer un peu quel genre d'expérience professionnelle on peut vivre à Affaires mondiales Canada, que ce soit comme juriste ou comme analyste de politique, qui est mon poste actuel. So first, let me start by saying that preparing Canada's participation to MC13 was a massive undertaking for Global Affairs Canada. As Professor Dufault was mentioning, the Ministerial Conference is the highest decision-making body of the WTO. It only comes together once every 2 years. And there was particularly high pressure for outcomes at this Ministerial Conference after MC12, so the last Ministerial Conference's success on the Fisheries Subsidies Agreement. For Canada, MC13 was a key multilateral event on our international agenda and also a high priority for our minister, as it's reflected in her mandate letter from the Prime Minister, and also given Canada's leadership in the Ottawa Group. So, as Professor Dufault was saying, MC13 took place over a week, so 7 days in total, because we also had side events. So there were days with packed schedules, several overlapping events, and that included, of course, trade negotiations in different formats, such as plenaries, smaller groups, but also a broad range of side events, bilateral meetings, and engagement with stakeholders, such as media, academia, and also the private sector. So MC13 was an event where momentum built over the days and came to what we can call a crunch time in the negotiations towards the end. And so, in fact, the conference had to be extended, as was mentioned before, and decisions were taking at the very last minute in the early morning hours of the last day. So to me, I think that demonstrates the hard work and the dedication of the delegations on the ground, where everybody was working basically 24 hours a day to try and achieve outcomes as much as we could. In terms of the contents of the negotiations themselves, I will leave the other panelists to describe them in more details in their issue areas. But what I can say in general, and Professor Dufault touched on that as well, is that MC13 happened in a challenging geopolitical context. We have increased divergence of views on what the role of the WTO is. We have rising trade tensions, active regional conflicts. We're still recovering from the pandemic, and we also have systemically important elections that are coming. So this has all made progress in the lead up and at the conference itself very difficult. And as such, it was particularly important to show Canada's commitment to supporting and strengthening the multilateral rules-based trading system, but also while remaining realistic and pragmatic on what could actually be achieved. So our approach going to MC13 was first to be constructive, try to enhance the existing trade rules wherever possible, but also ensure that any outcome would preserve the institution and lay the foundation for future work. And on this last point about the future work of the organization, one of Canada's key objectives was to support ways for the WTO to continue to demonstrate its relevance as the key forum for global trade, and also for it to be equipped to respond effectively to modern challenges. So one way Canada did this was by pushing for the scheduling of the 2 ministerial conversations that Professor Dufault was referring to, on trade and inclusion, trade and sustainable development, and also the question of industrial policy, which are all highly relevant issues today. And we also held 2 meetings of the Ottawa group at MC13, where we discussed WTO reform with partners who are also committed to improving the organization and ensuring it works for everyone in today's context. In terms of the outcomes of MC13, even though some could have hoped for more deliverables, I tend to be on the optimistic side as well. And there were notable ones in addition to ones that were mentioned before. So one I can say is the accession of Comoros and Timor-Leste as new members of the WTO, which demonstrated the continued relevance of the organization and especially for developing countries. There was also a decision on extension of certain aspects of the least developed country treatment for members who will be graduating from this category. So an extension for 3 years of certain of these benefits. There was also the renewal of the e-commerce moratorium for another 2 years, and my colleague Katrina will talk about it later. But all of this to say there were some notable outcomes that deserve to be mentioned. And outside of the official negotiating outcomes, it's always important to keep in mind the high value of multilateral events like MC13 in global affairs in general. It allowed for a week, 166 ministers to interact in person, and they advanced priorities not only at the WTO, but also other bilateral or regional trade objectives that they have, and this is non-negligible. For example, our own minister had the opportunity to interact with 23 of our counterparts. That allowed us, Canada, to strengthen our trade partnerships with a broad range of countries. And this brings me to my last personal insight from the ground. As a first-time participant in a multilateral conference like this, I was able to witness firsthand how important information sharing and alliance building are in those events. And more specifically, I realized the importance to do that with a broad range of partners from all regions of the world and all levels of development. I think Canada has a reputation to be a bridge builder at the WTO, and this was definitely one of our strengths at MC13. And I think overall, MC13 has shown more dialogue and cooperation between diverse groups of members than rarely before at the WTO. So I think I will stop here for now, and I'm happy to answer any questions later on in the language of your choice. Merci beaucoup.
Leonie. So now I'd like to invite Matthew Smith who is the Chief Agriculture Negotiator and Director General at Agriculture and Industry Canada.
Merci beaucoup. C'est un plaisir d'être ici avec vous, puis de parler un peu plus de conférence, puis tout ce qui est passé sur l'agriculture. And it was a very, very busy time for sure to go through this. And I remind people that haven't thought too much about the WTO, that just looking at the fact that they've divided up the world, every kind of good, anything you can hold in your hands that's traded is either agriculture or not agriculture. So you have those two negotiating groups, and that's everything. Cargo ships, screens, displays, anything you could imagine is in the one category, and there's food. And there's lots of good reasons for that. One of them being that everybody produces food. There's no problem in Canada with us saying it's okay that we buy most of our displays from Korea, or that we don't have that capacity here. People live with that, but they don't want to hear in any country that there's no food unless we're counting on neighbors to send it to us. It quickly leads into beyond food security and national security for a lot of countries, but it's also culture and tradition and a part of people's everyday lives and history. So there's a lot of passion in it. That means that those conversations in trade are also very passionate. For Canada, it's a chance to try and make sure that we still have a framework to get the tremendous amount of food that's produced in Canada out to other markets. We have, yes, a commercial interest, but I think when we talk to other large exporters of food, like those in Latin America, like Brazil, for example, there's also, as you think about climate change, a real responsibility to make sure that if you have the capacity to make a lot of sustenance, to get a lot of calories out the door, to feed people around the world, it's important to maximize your ability to do that, because there isn't enough. Each country can't be, despite that desire to be self-sustaining and produce enough food. So many just never will be able to. Their populations are far greater than the land they have available. Japan is a classic example of a country that has tremendous wealth, but will not be able to feed itself independently, and knows that it needs to be working with allies to make sure that that happens. And I think when it comes to those WTO conversations, it has been a little while since we've seen an ambition or kind of a consensus, because it is that consensus-based organization, to sit down and completely revamp the way that the rules look, in the sense of opening markets further, allowing for more liberal trade in food. There's a real political cost to changing the status quo in any country in those spaces, and it's a big conversation to have. But there's also the realization, I think, of a number of countries that what has been created in the architecture of the WTO is very valuable. And the kind of rules that Canada, for example, negotiates in bilateral free trade agreements, like the one we recently renegotiated with the United States and Mexico, it doesn't cover the kind of subsidies that governments provide to agriculture. And that's because it's a big deal to agree to spend less to help out your farming sector, and to allow other countries maybe to come in and have a piece of that space, when you're not making a deal with all of those who might benefit from it. And with a completely global market for food, you really want everybody to be a part of that conversation. And the only place to do that is through the WTO process. And so you had a very, very clear interest from delegations, large and small countries and developing countries alike, in those agriculture conversations. And for Canada, we look at the space for the kind of subsidies that are spent, and we find that there's, yes, a lot of money spent in countries you might expect, like the European Union and the United States. And even Canada, to an extent, spends some money in this sector. But there's a tremendous amount, both in absolute terms and even in relative terms, in China and India and in developing countries as well at the WTO, that go into that space and have a really big impact on markets. And one of the ongoing conversations at the WTO about cotton has always shone a light on the fact that for all the amount of money that governments in OECD countries spend on overseas development assistance, it pales in comparison to the amount of money that could potentially be available in some of these markets if there were simply less subsidies provided in richer countries in that one key crop. It's very hard to compete in a market space with a really large degree of subsidy. So preserving the space is something that we don't take for granted. And even though you didn't see an outcome from this ministerial conference saying, let's have some further tighter controls on these subsidies, from our perspective, what you also didn't see is an agreement to do less and to have more of a free space for people to act in that area. And there's quite a big conversation, both at MC13 and ongoing, about that kind of subsidy space. I think you see Canada joining with like-minded exporting countries in Latin America and Asia. You had strong voices from Thailand, from Costa Rica, from Brazil, from a number of Latin and Central American countries explaining that this was a very important space for them. You also have quieter conversations with a number of African countries that say they have a complicated path to explore, but they're very concerned about unpredictability in markets. Getting food from another country that comes in at a low price can seem good in a particular circumstance, but it may offset the ability to have a stable employment in rural areas in that country for a time. And what is even worse than one extreme or the other is the constant change and the uncertainty. So the stability that comes from the disciplines of the WTO are very good. That's where a lot of the conversation. We heard earlier in our conversation about the consensus-based model. I think it's true that there was a lot of engagement from those 166 delegations across this space, but I am waiting to see, quite honestly, what the reaction from a number of developing countries will be on agriculture, because the reality is that there was a very small process for most of that ministerial conference. You had a small group with countries like the European Union, the United States, China, Japan, Canada, discussing in a room smaller than this for the entire room, what a lot of the possibilities between bigger players in agriculture might look like. And that necessity of trying to understand where those who spend or buy the most in agriculture might be able to go is always a part of the process in finding out what could happen in a bigger room. And I do think that as time drew on in the conference, there was a lot of conversation about how can we next time have more participation and more transparency in these kinds of processes, because there is so much at stake and people do have such an interest in it. So, I'll leave some time for other speakers. I'm very happy to take questions about some of the other issues. There's obviously more to agriculture than just that kind of subsidy issue. Is the real big thing for Canada right now. We have been trying to go out and improve the access that we have to other markets through our bilateral trade agreements. We've been quite successful in doing that, but there's no way to replicate that subsidy space. So that's why it really sticks out for Canada when we get to the multilateral conversation. Thank you very much.
Merci, Matthew. I would like to invite Katrina Ellis-Cannon, Deputy Director of the Trade Division at Naval Affairs Canada. Talk to us, I think, about digital trade.
So I'm Katrina Ellis-Cannon. I'm a Deputy Director with the Services Trade Policy Division, but I actually don't work in all services on e-commerce and digital trade, which is what we like to refer to it now. So I'm going to talk a little bit about the WTO work program on e-commerce and the moratorium on customs duties, and I'll explain what both of those are, and MC13. I unfortunately was not there. I was on the receiving end of many WhatsApp messages, like below, so I'll try to channel that today. So the renewal of the work program and the moratorium were key priorities for us going into MC13. More broadly, Canada has a very strong interest in having trade rules around e-commerce and having this factored in part of our approach through our bilateral free trade agreements, which is one pillar of our approach on digital trade. We're also looking at the rise in digital trade agreements, like the Digital Economy Partnership Agreement, and then, of course, our work through the WTO. So at the WTO, in a very strange moment of foresight in 1998, they established a work program on e-commerce. The WTO is not really known for looking ahead, but they did in this case. And they agreed to create a work program to discuss matters related to e-commerce and to simultaneously a 2-year moratorium on customs duties on electronic transmissions, which has subsequently been renewed at successive ministerial conferences or by the General Council. So what does that mean? So the work program is more of a committee-like structure. There's discussion on topics related to e-commerce. And I think it's important to note that e-commerce is defined very broadly in the WTO. We're not talking about buying and selling goods online. That is separate. We're talking about intangible products and things that you download. So what the moratorium did on customs duties on electronic transmissions, essentially members committed not to apply tariffs on those types of intangible products or the things that you download, which was a bit of a gray space between the GATT, which governs goods, and the GATS on services. I think it's important to note that there actually are no legally binding rules. I thought that might be relevant for lawyers or prospective lawyers. Ministerial declarations are political decisions. They're not legally binding. So the moratorium on customs duties is actually a political declaration and something that we abide by, but wouldn't necessarily stand the test of time. Certain members, including Canada, are trying to change that through something called the Joint Statement Initiative on e-commerce to establish some rules around that, and I'll come back to that later. So MC13. So what happened before MC13 and what happened at MC13? So before MC13, there were actually 4 draft decisions on e-commerce that were in front of ministers, which is a lot. That's a lot for ministers to contend with. One of them, Canada, led on the drafting together with Switzerland, and we had 54 members who had co-sponsored that. The ACP group, so the African, Caribbean, and Pacific group of members, they also tabled a decision. And to my knowledge, it was the first draft decision for renewal of the moratorium by a large group of developing countries in sort of the history of e-commerce. So that was pretty significant. And then on the other side, as foreshadowed in other people's interventions, you have India and South Africa being the naysayers on the moratorium, and then also Indonesia, and I'll come back to that a little bit later. As others had mentioned, just one single member could block the renewal of the moratorium. So the fact that these countries were so keen to block did pose challenges. So we went into MC13 with 4 decisions on the table for ministers and no consensus. I think somebody used the term earlier about paralysis, so I think that might describe a little bit of what it was like going into MC13. There were also no formal negotiations on the ground at MC13, which made it quite challenging, I think, to kind of bridge gaps sort of on the ground. But there was a lot of work done behind the scenes to get the text over the line, and it was renewed at the 11th hour. And I believe someone on our delegation used the term in extremis. So under extreme circumstances and a lot of, I think, late night phone calls. The key detractors, India, South Africa, Indonesia, they had different interests. And so I think it was particularly challenging to try to address those because they all had their different and unique issues. And I think Indonesia warrants specific mention because they are the only country that have established a framework to apply customs duties on digital products. And they moved this from a very theoretical debate. Even 2 years ago when we had the last ministerial conference, we said, well, this is how do you apply a customs duty on a digital product? But Indonesia is moving in that direction to at this point, looking for importers to self-report what they're bringing in terms of 5 forms of digital products, so things like software, multimedia. But it does raise a lot of questions for us in the future in terms of our existing WTO commitments, rules of origin, other fun topics that are near and dear to my heart because I used to negotiate goods. But anyway, we'll put that aside. So ultimately, we have the renewal of the decision, but many view it as the last renewal. The text of the decision commits members to continue our discussions in the work program, particularly focusing on this development issue, and also continue to discuss what exactly the moratorium is, because there are debates around that. And it did renew the moratorium, but it specifically said that the moratorium and the work program would expire by NC 14, so the next ministerial conference, or March 31st, 2026, whichever is earlier. So what does that mean? The concept of expiry of the moratorium was first included in the MC 12 decision and was only in relation to the moratorium. But it included a caveat unless the ministerial conference decides otherwise. So in the absence of that language, there are some who are interpreting the MC 13 decision to mean that both the work program on e-commerce and the moratorium would end. Others feel that the ministerial conference and ministers always have the prerogative to take a decision to release. So it's clear, at least in the MC 13 decision, that these two issues, the work program and the moratorium, are linked. And it's also clear to me that we have some work ahead of us. We have under 2 years to kind of sort out what we're going to do. It's pretty early in terms of engagement. And what this might mean and what the expiry might mean, but those are the discussions that we're trying to do. One element that's coming into this, particularly for Canada, is the plurilateral negotiations at the WTO on the Joint Statement Initiative on e-commerce. So this is a group of 90 WTO members that are aiming to establish a baseline set of rules on digital trade. There are no specific rules at the WTO on digital trade, so that's what this aims to do. It looks to cover good regulatory practices, things that we've perhaps discussed in the work program, like online consumer protection. And of course, for Canada, prohibition on customs duties would be considered a baseline. So we're also seeking to get that through these negotiations. That said, the 90 members, we have an interesting makeup. India and South Africa are not part of the Joint Statement Initiative, but our friends in Indonesia are. So certainly more discussions to be had there. And whatever outcome we do reach in the Joint Statement Initiative will no doubt have an impact on the multilateral discussions on e-commerce. So, I mean, I think Matt said, you said we didn't agree to do less, and I think that's a great phrase to describe e-commerce as well. So I would say a success.
Optimism, success, let's not do less. Perhaps we'll do more. J'aimerais maintenant inviter Claire Citeau, qui est présidente de Trade Bridges.
Yeah, true. Thank you. And as a starting point, I will say that I'm not a trade negotiator and I'm not a lawyer. My background is I feel a bit intimidated, but I'm happy to speak to some of my experiences here. I started as a equivalent of a trade commissioner working for the government, and then I moved to Ottawa to work for the Canadian Agri-Food Trade Alliance. Close to 9 years working on trade policy, sort of building the bridges between the agriculture sector and the government, the negotiators who do a very important work in the context of bilateral and multilateral negotiations, but also the WTO months as well. And I'm now doing some consulting work for the European Chamber of Commerce on the ag sector, the meat sector, and some countries and institutes in Latin America, all related to trade policy and in particular sustainability work is a fascinating world for, if you want to have a side discussion afterwards. That we have to touch. So I'll talk a little bit about some of the outcomes about that came out of MC12, positive, negative, broader perspectives, and perhaps. And because I'm not a negotiator or a lawyer, again, perhaps why it matters so much for business, as Matthew explained, and what we can do about it. And I will stress a few points on the importance of industry-government collaborations. So, and for the record, I am the trade optimist as well. My comments may negative side. Dr. Ngozi, following the conference, said, and I quote her, despite the more than challenging context, we concluded MC13 with a consensus and a number of declarations. That's why personally I see the glass half full. But if you look at a number of statements that came out on the part of chambers of commerce around the world. Not many have commented, I will say, but a few that were there, some Canadian stakeholders, of course, many Canadian stakeholders, some from Latin America and the US as well. If you look at those statements, you will see that many do say it is good in a way that things didn't fall through the cracks entirely. But many see the glass half full. The reality is that the glass is quite a lot less than half full. And we should be careful to not be overselling the results, because I think ultimately that may be unhelpful to the effort and the work that our negotiators and governments around the world are trying to do. And it could encourage complacency. Members can and should do better. I think if you look at MC12, I was not myself at MC13, but I was at MC12. Right after COVID and the start of the Ukraine, the war in Ukraine, and we got more results and better results there than we did, I think, at MC13. So it is important to continue to positive outcomes. New countries joined newcomers. There's a few commitments to continue the work ahead, of course. The adoption of some text on investment facilitation, services, domestic regulation, and the transition of countries graduating from least developing countries status and remaining certain benefits. Those were some of the important outcomes. I think what was also important was the package that was put out ahead of the conference. And I think one of you mentioned that there was a list of what it is we are aiming for. And I think really this is an important signal for businesses as they look ahead and need that predictability and stability moving forward. So to get a sense of what it is governments are working towards, I think is quite is encouraging. On the disappointment, you've heard some already before, agriculture, fisheries subsidies, in particular because there's been so much work done on this. We're so close. Agriculture, I think there was, and to speak a lot better than I can on this, of course, but some of these, many of these issues are not new, whether it's subsidies, whether it's market access, whether it's the SPS declaration, and there was some really good outcome at MC12 on this. So it's difficult. And I think you rightfully spoke to the fact that because it's related to culture, agriculture tends to be really a bit of a different situation. Some of the other disappointments on the district settlement system, although there have been some discussions and some comments on the part of the US, I think is perhaps encouraging in light of no comments in the past and silence for a number of years on that front. I was interested in your comments on digital trade and the moratorium upfront, because this is probably businesses that I work with. Even this morning, they are wondering what is going to happen in 1 year from now, in 2 years from now. It is the number one issue for many of them, small, medium, large corporations at this point in time. So in terms of broader perspective, let me bring a more nuanced comment here. I think we need to be clear that largely disappointing outcomes to this Ministerial is not a failure on the part of the WTO. And I think we perhaps speak too often about the WTO and not the WTO members. It is rather a failure on the part of government make the common sense compromises needed to get trade and welfare enhancing field over the line. The quick take is that base domestic politics have trumped effective international cooperation in Abu Dhabi. And I think if you look at the outcomes, the decisions on e-commerce and development do keep the WTO afloat. On ag and fish in particular, certainly this is something that would have really, had we seen progress, I think we would have really seen the WTO move forward in a substantive way. So the glass is less than half full, but it is not completely empty. And going back to some of the comments that Matthew started with, yes, we do have those bilateral regional agreements, TPP, the CETA, the CUSMA, and so forth. But we are in large part with those agreements because perhaps of the inability of the WTO to reach multilateral agreements. Yet it remains the only place for companies to address multilateral issues like subsidies. There is no other forum. Those cannot be addressed on a bilateral basis because they have an impact around the globe. If India decides to build up its stocks of cereals or various commodities and decides to dump them in a market at a very low price, this will have an impact on prices around the world. This is not something that we can address on a bilateral basis. You've got to go to the WTO for. What do we do when industry is at the WTO? We have regular briefings with our negotiators, with ministers, with foreign governments and industry counterparts as well. We host roundtables with various partner countries, and at times we're not discouraged from holding press conferences. If you look at some media coverage a couple of years back, there was a lot of tension throughout MC12 and a lot of criticisms against our coverage of India, I will say, and agriculture and India holding the cards and not wanting to reach a deal. So what we did was at the time with the Canadian agri sector, we held a media conference with counterparts from the EU, from Brazil, I think Ecuador was there, from the US, and we explained the importance of certain measures and certain decisions and some of the dynamics we observed that have an impact on the pulse sector around the world, or the meat sector, or canola and so forth. And I think this is an important exercise because no one else is explaining to the broad public what it means. And those regular conversations are important to push ministers. When I referred earlier the domestic politics that influence the negotiations at the negotiating table, I think it's important to bring the public on board if we want to move this goal. Some of the work that I was doing was at CAPTA on the WTO, and I think we don't see that enough in other sectors. And I was commenting earlier with someone here that we need to bring the WTO closer here to better explain it to not only businesses. The negotiations that happen in Geneva, in the Geneva bubble, are in a way very opaque. It's not easy to understand and to comprehend when you're based in, your farm in Alberta or your food business in Mississauga. Yet those decisions have a direct impact on the level playing field, on prices, on predictability, on stability, on red tape. All of that is ultimately what impacts businesses. And the number one thing that businesses have in mind when they hear WTO or bilateral free trade agreements or regional trade agreements is the level playing field. That is the number one thing. They don't want to be at a disadvantage vis-a-vis their competitors from Australia, from the EU, from the US. Then comes the need for, then comes prices. What decisions, what agreements amongst various countries will have an impact on their ability to sell a certain product at a competitive price or at a better price than others. Transparency, what mechanisms exist, and there are some in the WTO and there are some in the context of bilateral agreements that exist to inform industry about regulatory changes. They need to know how to compare, how to respond, how this will affect their own supply chains. They need to prepare comments. So all of these factors, competitiveness, transparency, stability, prices, are things that they are worried about day to day. HR, staffing, costs. So it matters. Not only does it matter, but without it, they cannot ship the products. Part of the problem is that this is, as I said, very, very complex, and it's so complex that there are some agreements that are in place, like the CETA agreement, that some companies don't even have time to really go into the details, and they continue to use WTO terms and not benefit from the CETA agreement. They need to hire someone to take the time to go through the agreement and understand how they can apply for certain tariff reductions, for example. So the point here is that all of this is complex. All of this is complex, and there is a need, in my opinion, to build a better bridge and a better understanding as to why trade matters, why the WTO matters, how the various free trade agreements function. And for that, it's really important to have a very strong and very good working relationship between the government and the industry. There is value in regular conversation. I think it is not necessarily obvious all the time, but it is very, very important. So there is value in collaborating with the government when we are on the industry side for a few reasons. First is to maximize our interest. If we are in contact with our negotiators, they better understand how they can either defend our interest or seek better access for us. But it's also an opportunity to make sure we don't avoid major issues. The CPTPP discussions, for example, were very complex and involved Japan, which was a big market, important market for us when I was on the ag side, but very complex as well on the sugar, on the beef side of things. We had very intense discussions and collaboration with the government, with the negotiators. So they understood the dynamics, what happens if that amount of beef goes in. And things are triggered, and prices or quotas are triggered in the market. Same thing on the sugar side of things. So there are various mechanisms that exist to engage. And for the future trade negotiators that are in the room or the trade commissioners, I cannot emphasize enough the importance of building strong relationships with the sector so they better understand your work. But you also play a role in educating the sector, whether it's through consultations, one-on-one meetings, debriefs. I think ultimately there's a need for industry to better explain their policy objectives, share market intelligence, as I mentioned, go through emerging changes as they happen. But also it's an opportunity for the government and industry to prepare for potential changes and for potential reactions. If something happens, if the government makes a certain commitment, how will the industry react? And it's an opportunity then to prepare both parties to mitigate and find a way forward. It's not perfect, but it's important. And I encourage you to view trade and trade policy as a bridge with 4 different pillars. One is industry. The second one is the political level. You always and constantly need the political to come to some sort of agreement ultimately. You need the industry to continue to be in constant collaboration with the trade negotiators that are here with us today. And you need Parliament and the broad public to understand why this matters, because ultimately the agreements that are negotiated need to be ratified and implemented. And this is not going to happen if the public is not on board. I think we live in a time as well where there's a lot of attack on trade. If you look at the Senate vote on the CETA agreement in recent days or weeks, I think we need to do a better job of explaining trade and the results.
Alors, merci Claire. J'aimerais maintenant inviter Nadia Bourly, qui est la directrice exécutive au Bureau du droit commercial à l'Affaires mondiales Canada, pour une dernière présentation de la part de nos panélistes, et en espérant que on va maintenir cette vision du verre à moitié plein, donc du verre à moitié vide.
Bon, je suis ravie de me joindre à vous, également comme ancienne étudiante de droit et maintenant à la direction du droit commercial international à Affaires mondiales Canada, qui est une unité conjointe entre Affaires mondiales et le ministère de la Justice. On est vraiment le centre d'excellence au gouvernement pour tout ce qui touche l'expertise juridique sur le droit commercial international. Et c'est avec grand plaisir là, que je souhaite aussi vous confirmer et vous partager que la pratique du droit au sein du gouvernement fédéral peut être tout à fait fascinante. Ça me fait plaisir d'en parler, soit par la suite. Donc, je suis ravie d'avoir l'occasion aujourd'hui de vous donner un peu une mise à jour concernant les réformes qui touchent au mécanisme de résolution du différend au sein de l'OMC. J'ai aussi noté très brièvement mon collègue Andrew McCracken, qui malheureusement est malade aujourd'hui, m'a encouragé à partager certains de ses messages avec vous. Alors, si le temps le permet, après que je vous ai parlé du mécanisme de résolution des différends, je vous toucherai très brièvement quelques mots sur l'accord sur les subventions pour les pêcheurs. So, on WTO dispute settlement, and what you may have heard about the appellate body impasse. So let me step back and maybe offer a quick recap of what is the appellate body and why it's important, And what led the US, right? Because let's be clear, it is the US that caused this impasse. So the appellate body was established in 95 as part of the creation of the WTO with the dispute settlement understanding. Basically, it's the second and final stage of a dispute settlement process under the WTO. So it's a standing body of 7 adjudicators, and they hear appeals to the reports of the panel in disputes before WTO members. So we have 7 adjudicators. 3 are assigned per case, and each of them have a term of 4 years. It could be extended once. I'll come to that later. So before the appellate body, which did not exist before, the situation was as follows. An individual party had the power to block the adoption of panel report, which is to say, a lot of panels reports were actually not adopted because maybe the losing disputing party would simply block the adoption, or maybe because a party would not agree with the legal analysis that was done by the panel. Now, in the current system, individual WTO members are unable to prevent the adoption of panel report, which is great. We now have what we call the reverse consensus. So we went from a situation where one party, could block the adoption of a panel report. Now you need consensus of all the membership to block the adoption of a panel report. But to address the fact that this approach did not provide members with the ability to raise concerns, let's say if you disagree with the panel analysis, the appellate body was established to provide an avenue for members to seek to correct legal errors and also to ensure overall coherence and consistency of dispute settlement decision, which again, very important for stability, predictability of the system. In addition, once the panel are adopted, the reports are binding. And that means that, they result in enforceable obligations on members. And if the losing party does not comply, the complainant, thanks to the DSU, now has certain mechanism at its disposal to further incentivize compliance, for instance, by seeking authorized retaliation. So overall, appellate body, very important for the security and the predictability of the multilateral trading system. All these agreements that we've been discussing, you do have, the binding ones, you do have, you can have recourse to the dispute settlement system with jurisprudence that is consistent, coherent, and with highly trained adjudicator. And this is very important for middle power like Canada, because we are dependent, frankly, and very much beneficiary of a rule-based international trade for our prosperity. However, following the creation of the appellate body in 1995, the appellate body process, did become a bit more complex and lengthier than what was originally envisaged, and that did cause some problems. So, for instance, due to the increasing complexity of trading disputes over the past decades, so more complex disputes, lengthier legal submissions being made by the parties, and frankly, more appeals being filed, almost by default, right? And all of which resulted in a much heavier workload for the appellate body and, did not allow to meet the 90-day deadlines that was originally contemplated. So taking us now to the impasse, what happened is that in December 2019, the appellate body finally lost its ability to hear appeals because of the lack of a quorum caused by the US blocking the appointment of new appellate body member. And so we knew this was coming, right? This was not a surprise. The US had been blocking appointment for a while. So why did the US do that? Well, the US is unhappy with the appellate body. So important to note, this is not a President Trump legacy, okay? This is the concerns of the United States with the appellate body are bipartisan in nature. They are shared by officials, by elected officials in Congress. It's a bipartisan issue, unfortunately. So even under the Obama administration, this is where we started to see some of these blocking of appointments. So very quickly, one area of particular concern for the US that I'll flag relates to trade remedies. And this relates to the ability of a party to impose duties on the imports of goods from other countries that it determines benefit from unfair practices abroad, either dumping by a company or unfair subsidization by the foreign government. The US has traditionally been very creative and it's in applying trade remedies to protect its industry. But it did not take well that the appellate body declare some of its practices inconsistent with WTO obligation, especially vis-a-vis countries that the US perceives as abusing, unfair trading practices, i.e. China. The US, was also of the view that over time, the appellate body became too activist, right? These long decisions with some obiter dictum, like all of this adding obligations that member had not agreed to. Also, the US was saying, oh my God, what's going on? It's the Secretariat that is drafting too much of these reports. It should be you, appellate body members, that draft, and US folks working in the Secretariat are telling us it's the Secretariat that is writing the reports. And reports being way too long. And the US view was like, the appellate body shouldn't opine on everything. It should focus on what is required to take a decision squarely to resolve the dispute. And from my time in Washington, DC, I was recently posted there. As I mentioned earlier, I can tell you that many contacts were sharing the view, even those that are strong proponents of a functioning dispute settlement system, they were of the view that the appellate body was a step too far in the US ceding its sovereignty. So this is something that obviously we need to take into account when we talk about how to resolve the impasse. But so as a result, the situation we have now is that since 2019, there's more than 20 panel reports that have been appealed into the void. What does that mean? The WTO is unable to adopt panel reports. So that means that the panel reports are non-binding and they cannot, and a resolution of these dispute proceeding is not possible until new appellate body members are appointed. It also means that the successful party is not able to seek, for instance, authorized retaliation in case of non-compliance. So this has a real impact. Including for Canada, for instance, where we have the US that has appealed into some of the decision that were in Canada's favor. So this is all what led us to the ongoing discussions to reform the DS system. As the member that had been the most vocal in its concerns with the system and the one that caused the impasse, the United States, who had, as Claire mentioned, for years had kind of been reluctant to actually engage in reform discussion, initiated informal interest-based discussion in 2022 to, show that they were willing to discuss. So there was a good outcome at MC12 where the declaration agreed by Ministerial was to have a fully and well-functioning dispute settlement system by 2024. And when we saw that, right, all of us, oh my God, 2024, the US agreed to that. Whoa, so this was viewed as a good and frankly surprising, but good outcome. So then throughout 2023, intense discussion took place in Geneva, between Geneva-based officials, Capitol-based colleagues, lots of conversation, and frankly, some good progress being made. And we have now a consolidated draft text that is still being developed, but that has looked at improving a number of areas for the dispute settlement system as a whole. And for instance, one example is, clarifying a bit the parameters of the WTO Secretariat's report. Okay, yes, we can clarify that adjudicators should have full responsibility for decision-making and that the adjudicators are expected to draft their own reports only with support from the Secretariat as appropriate. We're also looking how to streamline the panel process. For instance, looking at setting up specific page limits for written submission and time limits for oral statements. Okay, and adjusting the time frame for the overall dispute so that we can get closer to a time where the overall timeline for a dispute was closer to the ones originally envisaged in the DSU, which is, 9 months to a year. So lots of good progress, but as expected, no big surprise at MC13. We knew that we were not far along to agree to an overall package unlocking the appellate body impasse. However, we were able to come with a ministerial decision, very short, very brief, basically recognizing the progress made in reform discussions to date. That was an accomplishment. And also reiterating the objective to have a fully and well-functioning system by the end of this year. So definitely glass has full, and I also want to be in the, after 4 years in Washington, I'm not sure if I'm still an optimist, but I want to be. So what does that mean going forward? Well, discussions are going to continue. Canada, of course, as one of the main users of the dispute settlement system, will remain very engaged and very constructively so to continue the discussions. I will say maybe quickly 3 key outstanding issues ahead of us. The appel review mechanism, right? And I discussed earlier, like this will not be easy. The US as a superpower is frankly very happy to go back to the gag days where they can force a political situation, right? So we'll have to see how to navigate all of that. Then you have some developing countries that participate in the process that have expressed concerns about accessibility. India, South Africa, Indonesia. They say that we need to do more for technical assistance and capacity building. So on that, Canada, we strongly support the fact that the DS system needs to be fully accessible. So we'll continue discussion to see exactly what these members envisage in terms of, what is required. And finally, last but not least, some of you may know the US has clearly indicated that it will want, as part of this discussion, an outcome on the use of the essential security exception. That is also pretty tricky. You're maybe aware that the US has invoked this exception to justify the Trump tariffs on steel and aluminum, some marking requirements on importing goods from Hong Kong. And the fact is, as I'm sure you know, there are exceptions under the GATT which allow a member to justify its otherwise inconsistent measures. But the member normally needs to demonstrate that its measure genuinely falls within the parameters of that exception. It's not a free pass. But here, the US wants measures that it declares to be taken for its national security to be self-judging and exempt from any WTO dispute settlement review. They say that judgment by another body of what the US consider is in its national security interest would be a total breach of its national sovereignty. So this will be a fun topic to continue to discuss, but again, very committed to pursue the conversation. Obviously, let's be frank, the outcomes of the US election will likely play a role and how this will unfold throughout the rest of 2024. But in the meantime, I just want to flag something that I think is pretty important, is the multi-party interim appeal arbitration arrangement, MPIA. Okay. So the MPIA is something that, and I think we can be very proud of that Canada spearheaded with the EU in 2020, just after the US succeeded in, blocking totally the appellate body. We led a group of 47 WTO members in creating this political commitment whereby we agree that in disputes that involve other MPIA parties, we agree that we will not appeal decisions into the void, and that if we have a disagreement or we want to appeal, we will rather resort to arbitration procedures that were outlined in some part under the DSU. So this is a mechanism that gives us can give us comfort, right? In case things go completely haywire, we have something in place. And the MPIA has already, we already have a full case that has gone through, and there are 3 ongoing disputes currently right now in the DA system where both parties are MPIA participants. If Trump wins, maybe the MPIA will gather even more interest from other parties. So an interesting few months ahead, but yes, me too. I'm optimistic, especially if Biden wins. So that concludes my remark on dispute settlement. And if you allow me, maybe I'll say a few words on fishery subsidies. People are not too tired of hearing me talk. So the fisheries negotiation, I think, is very interesting and really illustrate a bit the dynamics that all my colleagues and Claire have pointed to. You know, something that's really important, lots of resource, lots of energy, almost there. Okay, but we were not able to cross the finish line at MC13. However, there is still, I would say, good news. This is also definitely a file where I think we can try to well. So, so the agreement on fishery subsidies is very important, right? So I think we want to recognize that when you're talking about issues affecting the global commons, like the ocean, subsidies can have an important role in supporting workers and communities. But we also want to avoid harmful subsidies that will lead to the depletion of global fish stock as a result of overcapacity and overfishing. So it's finding that balance. These conversations started as part of the Doha Development Agenda back in 2001. Negotiation did not, go anywhere. The SDGs in 2015 breathed new life in the negotiations. Then there was the pandemic. But then April 2021, the WTO new Director General, Dr. Ngozi, she said, fisheries negotiation, top priority in the lead up to the 12th Ministerial. And I think that gave a very good impetus for members to focus on that. And, it led to an agreement, which was a significant achievement at MC12. The agreement was not complete. It covered things like subsidies, prohibiting subsidies, going to a vessel or an operator engaging in illegal fishing, or it dealt with subsidies related to overfish stock, but a few other key areas were left out. But nevertheless, an agreement was put forward. It's now been ratified by a lot of members. Actually, 10 more members during MC13 deposited their instrument of accession. And there's the hope that this agreement could actually come into force this year. This would be a record pace for the WTO. So that is still a very positive development. Now, in terms of what was the crux of the issue at MC13, again, what I hear, lots of engagement from members was very constructive, including the big players, US, EU, and China, but wide divergence of views remain, specifically on special and differential treatment issues and the main subsidies discipline. At the end of the day, I understand that there was a certain coalescence around what a subsidy outcome could look like. There was also good discussion on transparency, which is a key aspect of disciplining subsidies. But as I said, big gaps on special and differential treatment, which is important, but obviously maybe the membership wants to think about, should developing countries that are large fishing nations be completely exempted from these new disciplines, for instance? So those are the type of questions. So we do expect that negotiation will resume in the near future, so we can remain hopeful about that. Voilà.
Merci, Alia. Si je peux résumer rapidement avant de passer à Céline pour les questions, je sais que on arrive mais il va y avoir du temps pour les questions, ne vous inquiétez pas. Je pense que ce qu'il faut comprendre avec une conférence ministérielle, c'est que ce n'est pas le début ni la fin. Ça fait partie du processus. Hein, on parle beaucoup du verre à moitié plein ou à moitié vide. Mais en fait, hein, comme Nadia vient de l'expliquer, si on a des résultats en 2024 sur un accord sur les pêches, ou les pêcheries, ou un accord sur peut-être le mécanisme de règlement des différends, ben, et que la conférence ministérielle a permis de faire des avancées, soit avant, soit après ou pendant, parce que souvent, ça comme on dit en anglais, it focuses the mind, right? If the ministers are coming together, then the whole machinery of government behind them has to deliver something, right? They're not just going to show up and, okay, let's go for a beer and chat, right? They're there to either make decisions or try to advance negotiations and things like that, right? And then maybe the end results will not be at the meeting. So you might say, well, you know, this is disappointing. They didn't actually agree on anything, or they didn't agree on this, or they didn't agree on that. But if 6 months, a year, 2 years later, you get an agreement because of the meetings that took place and then the decisions that were made and then the follow-up that happened, or the acceleration of certain negotiations that happened beforehand, this is success. It's not guaranteed, but those meetings are really important. So either at the WTO, or if you talk about the G7, the G20, often those meetings where, you know, the senior leaders, political leaders come together, it plays an important role. So we should not dismiss it just because at that particular time, this thing didn't happen. This agreement was not, you know, there was no agreement at that. Okay? Donc, je crois que c'est un élément important, selon moi, qu'il faut garder en mémoire lorsqu'on analyse ce qui se passe. Donc, il faut voir ça dans un processus beaucoup plus large que simplement la conférence ministérielle comme telle. Alors, maintenant, j'aimerais inviter ma collègue Céline Brauman, qui est professeure adjointe ici à la faculté de droit dans la section Common Law, et elle va animer en fond vos questions. Céline, moi, je te demanderais de venir ici. Les panélistes, experts, expertes, restez là. Ça va être plus simple de tous vous avoir, je pense, devant. On vous entend. Et puis...
Thank you very much. I have the honorable role of the moderator of the Q&A session. In addition, is that we can also receive questions by the audience that is online, so not just the in-person audience. I don't see any Q&As or questions online yet, so it's just a link for now. I will have about 25 minutes for this. I would ask you to introduce yourself when you ask a question. I will pull 2 to 3 questions at once and then hand the questions over to our great panelists to answer them. And in case there are no questions yet, I will also be happy to abuse my role as the moderator. Please, especially among the students, feel free.
I have a question for Matthew. So
could you introduce yourself?
Oh, yes, sorry, this is Laura. All right. My name is Karen Serrano. I recently finished my master's in international affairs over at ICEA. I'm currently working for the government at the CRTC. Sorry. So my question is for Matthew. I wondered if you could talk a little bit more about public stockholding issue. I know that was one of the controversial aspects of negotiations. And I also wanted to know if you could talk a little bit about Canada's stance.
Well, the second question,
I have also a question from Matthew.
I don't think you have to introduce yourself.
Je sais pas, je parle en français en anglais. You spoke a lot about subsidies, and I understand very well that multilateral forum is the only place where you can talk about subsidies, because one country won't stop using subsidies, the US won't stop unless EU does and all that. But I was wondering, in those multilateral forums, are there discussions about the other important things for Canada, such as GMO food or PPM, process and production method, the way the food is done? Are these issues just for dispute, or are they also discussed in those ministerial Or is it just about market access, sort of coal tariff and subsidies?
Yeah, third question, please.
Still on agriculture, so David Farrell, I'm a professor at the University of Sherbrooke. Maybe to emphasize this question to Matthew. I'm from Abu Dhabi, so there was during the ministerial a crisis between the declaration of the ambassador of Thailand and India, saying that India is not correctly using its right holding for food safety. And maybe can you, I wasn't sure to clearly understand the position of Canada on this point in particular, because there was some Northern countries saying they agree with the position developed by Thailand. So maybe can you just clarify if it's possible?
I would say let's wrap up the first round of questions with something balanced, but.
Well, there is a bit of a theme, in fact, I think that connects all three of the questions. And this, maybe just to start with, is it all about market access and subsidies? At the work of the WTO as an organization, no. But at a ministerial conference, in fact, yeah, there is very little space where some of those other issues would be talked about. They were not discussed in the agriculture portion at all of the WTO. The chair of the agriculture negotiations prior to the event made some efforts in the fall. In fact, the Director General held a meeting of senior officials in October to try and push along the fact that there was so little in many areas, agriculture included, for ministers to work with. And this was a concern that this would lead to an inability to have some outcomes. Part of that came in, frankly, because there was not as much time to prepare as you would expect for a ministerial conference. India blocked, with some other countries, the naming of a chair for the agriculture negotiations for months and months, which meant that you didn't even have meetings in Geneva to prepare. And then coming to October, in senior officials meetings, you had definitely some kind of an effort to say, let's talk about export competition, about market access, about subsidies. But no, you didn't have a space where people were talking about process production methods, technology. Those are certainly interesting for members, of course, and there's committees, Committee on Agriculture, Committee on Sanitary, Phytosanitary Measures, Committee on Technical Barriers to Trade, where you'll have lots of conversations and even some kind of more exploratory discussion panel type events, maybe that will be hosted by a small number of countries. So I wanted to answer that first, but then to get to some of the other role that public stockholding played, that's an issue where you have a very large proportion of humanity receiving direct aid from the government of India. There's 800 million people that receive direct food assistance from the government of India in India. So it's a pretty consequential project when you think of just administering such a thing. When you're taking the government of India's perspective, that is a tremendous responsibility to be directly feeding that many people. It's also obviously going to have an impact on markets. And India's taken the perspective that this program should include an element of keeping a lot of grain, a lot of rice in storage. That should be procured from Indian producers, and that ends up having a big role to play in rural incomes, in prices. Countries like Brazil have been very articulate in saying we have a very big population as well. We run public stockholding programs, and we manage to do it at market prices. We don't use the most distorting type of subsidy, kind of going in and dealing with the price as the government. Why is that not something that India does? That's a question that Brazil constantly brings to those conversations. And Thailand was very active in the last ministerial in MC12 and the periods in between and at MC13 in saying the Thai economy is one of the big suppliers of rice. And when India, I think that the main message that Thailand brought to the conference was India says that it needs to have this kind of very distorting price support because it's very important to manage food security. But India has numbers on its foreign trade website saying that India's exports have gone up tremendously in the last 5 years, and that it's one of the biggest suppliers outside of India of rice and competing with Thailand. And Thailand, I think, did a job of bringing a lot of attention to the tension between those two sides of the way that that program operates and the impact that it has on countries like Thailand. But to the question about, this actual kind of tension between the governments, I think there was a lot of passion in the way that the Thai arguments were made. The Indian government made formal protestations to the Thai government that was not appreciated, and I think that was a big story around the conference because you don't see a lot of that type of interaction at the WTO where governments are going to go after, individual delegations rather than just talking about the issues on the table. And I was in the room for the kind of comments that were made, and the Thai representative never, in fact, said the word India. I mean, it was quite.
Nobody pronounced India at the ministerial conference, never.
That's right. So it was not that something special, some special lack of decorum that had never been seen at the WTO was the source of this conversation. I think what you do see and what is a cause of concern, I think, for a lot of WTO countries is what after this conference will some of the conversation look like, where you have a number of countries that have very few resources to go to the WTO. They don't have many officials in a foreign ministry who can follow this full time. They have small delegations, small amounts of resources to make changes in your policy, to decide as a developing country that you're going to adopt a position that is based on some new facts, new information, but not your long-standing national position. It's a lot of work inside the government to get the policy developed, to get the political cover to sign off on this. And now, you also have this question of, will individual diplomats in some of these smaller delegations feel that their personal space and employment will come in, be brought into question by foreign governments. So it's a space where you kind of wonder how easy or difficult will it prove to be to have some conversations like this. And one of my observations is that it's very unlikely that a lot of smaller delegations would take that risk, get into a more adversarial position with countries with whom they're aligned on perhaps other issues outside of agriculture in the broader space. If there's not the promise of a big outcome in the larger WTO conversation, if it's only theoretical, why put it out? And I think that is also a challenge the organization will face in future conversations. I hope that. And also I think there's a question just about how does Canada look at public stock? And I think that we tried to be very clear that the objective of running a public stockholding program, of trying to look at stabilizing food prices in your country, no concerns, perfectly reasonable objective, something that every government at certain times will do, including ours if there was some kind of major failure in a big crop for some reason unforeseen. And we're really just trying to advocate that it be done in a way that's the least distorting possible. And we work with a number of countries to advance an alternate proposal for how you could have the full flexibility to respond to this kind of a policy challenge, and showed that actually it's really only 5 or 6 countries whose subsidies reach a point that matter, that spill over their borders and change the global price. Every other country is not going to have that impact. And so there's lots of room for essentially all, but the very largest developing countries, and even countries period, to have more flexibility than they do today under the rules. The main thing is to constrain those who impact global prices. And so that's the Canadian position.
Thank you very much. We have two questions on the Q&A board as well. I think we're question on the room. I will start with you while I pull up the question, and I will also read it out aloud for those online who cannot see the questions. I think only the moderators can see the Q&A questions. Please go ahead.
I'm David Plunkett, a retired negotiator, among other things. I'd like to come back to a couple of points that Claire touched on. The explosion, proliferation of regional and bilateral agreements started 15, 20 years ago, when the Doha negotiations were just grinding away to the point where even the EU made a significant policy change to get more involved with the bilateral issues. Now you see them everywhere. And it basically, you can find all sorts of issues all over the place, but it came down often to the fact that in absence of anything real happening in Geneva, countries sought other solutions for their problems. And while I listened to the half empty, half full discussion and was my background in stuff knows I had to be an optimist too, so but I think there is a real fear that if countries, and I agree with Claire, this is not the WTO's fault. This is the will of countries. And if they don't get their act together, you are going to see an increasing proliferation of solutions such as the ones that are happening in the dispute settlement as countries try to fix the problems. And that's under normal circumstances without getting into all this populism and eventually burning down the whole house. So I think this is a critical time for countries to be looking at this WTO and really, if they don't fix it, something will fix it for it. And no matter how many members you get, it may become increasingly irrelevant in real terms.
Thank you very much. Anyone who knows this room well, do people online hear the answers from the audience? Including Leonie?
Mike is here.
Leonie, can you hear the answers that come from the audience? Or would we have the
Questions.
Sorry, the questions from the audience and also the answers?
We can go with the questions in the audience.
So you can hear them?
Yes, I can.
Okay, I'm just unsure where the microphone is in the room. Thank you, perfect. There? Okay, great. I will summarize the two questions that we got online. The script is a little small. First one is, how is Canada planning to make its engagement with trade and gender more concrete? And the second one is, could you address Canada's conclusions, positions on how to create transparent and predictable environment for Canadian investors in developing countries? And I think this is a very good point because I believe there was an additional movement in the direction of facilitation of foreign investment. So,
more questions?
So we have three at the moment, but just to any of the panelists.
Well, maybe just picking up on the point that members will find solutions if the WTO isn't functioning. I mean, I think we're seeing that already with the joint statement initiatives that were launched at MC 11, including on investment facilitation, which I think is what that second question there likely alludes to, which included on e-commerce, and on domestic regulation. So, and those are a subset of WTO members trying to pursue these more plurilateral agreements. They're called joint statement initiatives because our friends in India don't like them. And so instead of a formal plurilateral negotiation, we call them joint statement initiatives. And so now domestic regulation has completed. That has a specific implementation process that's proceeding. I'm certainly not an expert, but my understanding is that's moving along. Investment facilitation for development has also concluded, and that was announced at MC 13. Now they will have to go through the process of trying to get that incorporated into the WTO. There is space for plurilateral agreements through the WTO, but again, it's by consensus. And so there are challenges. And then, of course, on e-commerce, those negotiations are continuing, and we're aiming for an agreement there. So I think the reality is that the WTO is trying to adapt, but it's hard because, you know, even if you get an agreement, for example, on e-commerce, you know, we've had many different challenges throughout the years negotiating the text of the agreement itself. And then even once you do get an agreement, then you have to go through the process of trying to get it incorporated into the WTO, where you hit other challenges. So it's kind of many hurdles. So I'm not sure if that really answers the questions, but I do think members are trying to find solutions to the problems that they're facing in terms of the process.
On the second one.
If I can-
Oh, no, you, sorry.
No, sorry, I was just gonna continue on what my colleague was saying. If I can say, I think it was one of my personal biggest disappointment that we're not able to incorporate the GSI on investment facilitation for development in the WTO framework. It's a decision that's made by consensus, of course, but the agreement would only bind the members who are parties to it. So it's disappointed to see that some members will use the consensus to block these type of initiatives, which are very easy wins and beneficial for developing countries as well. And if I can maybe start an answer on the trade and gender part of things, maybe one thing I can flag for MC13 in specifically is the ministerial conversation that I mentioned earlier on trade and inclusion. It was a first for a ministerial conference to have this type of discussions where ministers were allowed to share perspectives multilaterally on the official program of the MC. The ministerial declaration also recognizes the contribution of women's economic empowerment to economic growth and to sustainable development. So these are wins that we had at MC13. But yeah, it's important to know that for the WTO, there's two definitions of inclusivity. For Canada, inclusivity includes the participation of all tranches of society, including women, MSMEs, or Indigenous peoples. But others see inclusivity more as in better integration of developing and LDC members into the global economy. So it can have two meanings at the WTO, but we think that both can be addressed in discussions multilaterally, and Canada's been pushing discussions forward in several fora in the WTO whenever possible. So that's what I would say.
Thank you very much. Are there any further contributions to these questions for the panel, or should we open up the further questions? Are there more questions in the room? Please.
Hi, my name is Amanda. I have a question on digital trade. Just reading the proposals from India and South Africa on the world program, and then reading Canada's proposals, I feel like there's a lot of focus on how developing countries say they're losing out on revenue, but I feel like the key point to address is what India says about lack of policy space, and that's the key argument. Canada, like, as a bridging country, is middle ground that you see in the two sides on the world program? Is one question. And the second question is on the JSI agreement. After the US backed down on the areas, do you think the agreement will be impactful? Because things like paperless trading they are regulated elsewhere by other organizations. So is there any impact from the GSI? Especially if there's no developing preferential treatment provisions in the GSI?
Thank you. My name is Marianne. I'm a student from the master's program. So my question is for Nadia. She mentioned that one of the way forward is for developed countries to offer developing countries technical assistance. And that is something that I hear said a lot or come across it in articles. And so my question is, from a practical point of things, what does technical assistance look like when it is being offered to developing countries, and what value does it add to the dispute settlement at the WTO?
Thank you. I think we have time for one more short question.
I have a question.
Sorry.
No, give it to her.
Yeah, sorry. Give it to. Thank you. My name is Isha. I'm the GD student. I want to ask a question about India because she mentioned the dispute settlement system and the applicability crisis. So I want to know, because the MPIA remains uncertain. So I want to know your idea about how the process will go in, because there's no guaranteeing that the efficiency will improve, especially the MPIA, they don't have the institutional support as the AB, and also they don't have enough arbitrators to assist in the process. And from their website, and I saw that they only have to solve the dispute. There's two, and there's ongoing one in 8 so far. So do you think it will be the future viable option? Because currently people cannot see the MPIA in the official WTO organizational chart. So do you think it will be a viable option in the future to solve the current dispute settlement system problem?
Thank you so much. That's a great question. And Gabriel, you have the...
Une toute petite question pour Claire. Sur cette question des petites entreprises, l'OMC a maintenant des dispositions sur les SMEs et tout ça. Beaucoup d'efforts est fait à Genève. Mais vous parliez et vous dites « we should do this, we should explain ». C'est qui le « we » Est-ce que c'est le gouvernement ou la Chambre de commerce? Et je triche parce que j'ai une autre petite question à tout le monde. Je n'ai jamais travaillé au gouvernement et je me demande, dans la pratique, est-ce qu'il y a une coordination entre les efforts faits au niveau régional et multilatéral dans toutes ces nouvelles questions, e-commerce, taxes, tout ça? Est-ce que c'est les mêmes équipes ou c'est des équipes différentes? Comment on coordonne les avancées? Je m'excuse, j'ai triché.
Say 3 minutes.
Never
know how strict it should be. And take 5 minutes for the excellent questions.
I'm happy to start on the dispute settlement question. So perhaps the first question on the support for developing countries' accessibility. I think there's a recognition that it's very important, again, to make sure that the dispute settlement is accessible to all members. There is already existing an advisory center on WTO law, which provides training to a number of delegations, including developing countries, and really, including LDC members. And I'm aware, I don't have the specifics with me, but there are a number of existing programs already. That said, can we do more? Absolutely. And so I think the issue here is we are committed to look at what can be done above what the current technical capacity building that exists. But we want to make sure and understand, what will be the most useful. And also recognizing that there are issues sometimes of distance, of, capital-based representation, virtual participation in potential meetings. Sometimes it's also for information purposes. It's not necessarily to become an active users of the system, but, we are aware of there's various interests and among that. And so, but just to confirm that there are already a number of existing programs, and we'll see what more can be done. With respect to the MPIA, I'm not sure I would say necessarily that, first, let me say, I don't want you to be left with the impression that I'm suggesting the MPIA is a solution to the appellate body impasse. I want to be very clear. For Canada is a very important priority to maintain a two-tier dispute settlement system. And we do hope to resolve the situation. And we're open to, discussing various concerns, but we do want to go back to a two-tier system. That's key for Canada. What I wanted to say is that should the appellate body impasse perdure, the great thing is that we do have a backup that can ensure that members that are party to the MPIA can agree to enter into an arbitration agreement. So perhaps just to quickly on the logistics, first of all, you can be a member of the MPIA. That's just a political commitment. Then when there's an actual dispute that starts between two members that are part of the MPIA, they can decide within, I think, 60 days of the initiation of the dispute to enter into an arbitration agreement. So that is certain. They will enter into an agreement that says, if one of us wants to appeal, we will use the arbitration provided under those guidelines, which are broadly aligned with Article 25. In terms of arbitrators, we have established a roster of 10 arbitrators. So we do have, those experts that are there. And there is also currently some level of WTO secretariat support. So again, I don't want to overplay the MPIA, but I certainly want to say that it is a fairly good, backup for now. Obviously, we hope we'll go back to a fully functioning two-tier, but I hope this clarifies.
Yeah, thank you.
Thank you.
Thank you for the two open questions.
Well, there were a couple on digital, so I'm happy to address those. So in terms of India's arguments around the policy space and whether there's a middle ground on the work program. On policy space, I think the whole point of the WTO and of trade agreements is to limit policy space. That is the objective. You're agreeing to limit your policy space and creating a more stable and transparent and predictable environment for traders on the other hand. So, I mean, I think that's the whole purpose of it. To go in a different way on the moratorium and on customs duties, and it would be more restrictive than anything that had been done, because no one has ever applied a tariff on a digital product or an electronic transmission. So we're talking about doing something that could potentially be extremely costly to consumers, to businesses, to a huge range of people. I mean, whether there's a middle ground, I mean, I think that's what we're going to be spending our time considering. I think there's a lot of work we can do in the work program. Whereas I think the moratorium is a little bit more of a binary decision at this point. On the joint statement initiative and the U.S. position, so yes, the U.S. did withdraw its support for some key issues around data flows and data localization. Obviously, this has had a huge impact on the negotiations. The perspective is that the agreement still establishes a baseline set of rules to ensure good governance around digital trade. So it is certainly going to be much less broad in scope than certainly Canada had hoped for initially. But from our perspective, we're kind of looking at this as a first step, and hopefully there'll be scope that in the future. And I did want to note, I mean, development is a huge part of the JSI and e-commerce. So certainly those are issues that we're also talking about, and it's a core for the league.
So it is true that, and I think it's important, this means the smaller companies have always tried to do business, but it is more recent that the WTO has tried to clarify and bring them more on board. Same thing with the women entrepreneurs, the indigenous peoples and so forth. So I think it is important, and we don't often realize that they are part of the supply chains, that they are doing trade, even though some of them don't realize. Matthew explained that the food we eat, actually the food we eat does not necessarily only come from Canada. It crosses the border at least 4 times, just across North America. The clothes, the cars we buy and so forth have crossed multiple borders, and it is big, but also the much smaller companies that are connected to it, and the work of the WTO in that area is important. Though we use it, I think it's all of us. It's the governments who I think governments, industry, academia, institute, the data research centers, the OECD and others that should bring all of us, I think, more together. And there's a tendency, and I'm not, I don't want to be critical, and I'm not the one saying this solely, but we have a tendency to work in our silos. You know, negotiators work in their world, industry works in its world, and we need to bring the together, because ultimately this is what needs to be delivered. I think it's that connection that needs to get lost. And I wish here in Canada, we spoke more about what the WTO does on an ongoing basis, the role it played during COVID on medical supplies, on food, what more needs to be done to bring all those. So it's the we is I think in large part government and
Thank you very much. Anyone would like to add something? Or any last words? We'll hand over to Patrick.
Je pense qu'on s'est bien rempli la tête. And I think as a debrief, I think it was a very successful debrief. I'd like to thank the panelists. Je voudrais remercier les panélistes, commençant par Geneviève Dufour, Léonie de Rome, Matthew Smith, Katrina, et qui nous ont vraiment offert, je crois, un tour de table magistral de ce qui s'est passé à la conférence ministérielle, on the WTO more generally, on the challenges that we're facing. Thank you to Céline for moderating the Q&A. J'aimerais remercier aussi la faculté de droit, les 2 sections qui nous accueillent aujourd'hui, qui ont aidé à l'organisation de cet événement. La chaire de recherche en droit du commerce durable, responsable et inclusif, dont Geneviève est titulaire. The Hyman Solway Chair on Business and Trade Law, which is supporting Gabrielle here, and well, my chair, the Italian chair. But this event would not have happened for 2 people, Nadia Bourli and Gabrielle Marceau. They are the ones who made this happen. They thought about it, they organized it. Everyone else was supporting, but really it would not have happened without it. So merci à vous deux d'avoir organisé cet événement. Et maintenant, ben, je vous invite à une petite réception. Il y a il y a à boire et à manger. Alors, voilà. Merci à tout le monde. Thank you so much for being here. Thank you for those online. À la prochaine.
And I'd like to thank.
Yes.